Session has two parts. The part one is the exclusive economic zone and continental shelf, and the second part is the high seas and freedom of navigation. For the part one, may we call on our speaker. We have Professor Natalie Klein from the Faculty of Law and Justice of the University of New South Wales, Sydney. She will be joined later by the discussant of Philippine perspective, Attorney Ana Cosme from the University of the Philippines Institute for Maritime Affairs and Law of the Sea. Once again, let's all welcome Professor Natalie Klein.
Thank you. Yes. All good? Is the music going to stop or do I sing? Excellent. Because the singing, no. The singing would not be a highlight. It might be memorable, but it would not be a highlight, I can assure you. Thank you all once again for joining us and for the opportunity to talk on continued discussion on the different maritime zones and the legal issues associated with those. And in this particular session, we'll be talking about the continental shelf and the exclusive economic zone. I'll probably spend more time on the exclusive economic zone because Professor Jay already talked a lot about the continental shelf this morning. So if we can have a look at our next slide, please. So you remember this from this morning, the different maritime zones. And so at this point, we've gone beyond the territorial sea, and we are now looking at the extended maritime zones, the exclusive economic zone dealing with the water column, the continental shelf dealing with the seabed. And when we're talking about the continental shelf in particular, we're talking about the seabed. So our focus is very much on really the resources of the seabed and states' rights and duties in relation to those. And what has happened within the law of the sea is that we have developed our own legal definitions of things that are otherwise a geological or geomorphological construct. And you will sometimes hear references to the continental slope, the continental rise, but primarily we're concerned with what the lawyers say the continental shelf is. So next slide, please. So in terms of rights over the continental shelf, as we heard earlier, I think it's always important to start with the continental shelf before the EEZ because it did predate its existence legally. And aspects of that early legal history then have fed into how we then understand the exclusive economic zone. So, as Jay mentioned this morning, when there was the initial discovery of resources in the seabed, then of course states started making claim to those resources. And one of the most influential claims came from the United States, where President Truman referred to the claims over the natural resources of the subsoil and seabed, and considered that it was subject to its jurisdiction and control. So it was quite a deliberate claim in as much that it was very much limited to the resources and that it was a claim less than sovereignty. Next slide. So a number of other states followed, making similar proclamations, but some states claimed full sovereignty over the seabed. And so one of the issues that then had to be resolved within the International Law Commission and then in the debates leading to the adoption of the 1958 Convention on the Continental Shelf was how to define the continental shelf legally. So initially there was some recognition of what the continental shelf actually is by referring to a depth criterion, but as Jay mentioned, even then there was some uncertainty about how you go about measuring the depth of the water and determining what the limits of a continental shelf would be, and also by referencing an exploitability criterion in terms of a state would be able to have a continental shelf for as far as they could exploit it. Then you also end up with a situation where the states that have the most technology available to them are also going to be the most advantaged in being able to claim a greater area. So there was dissatisfaction, as you might well imagine, with how we defined the continental shelf from the outset. So by the point that we got to the negotiations under UNCLOS, there was an effort to reconsider how we understood the continental shelf as a legal term and to try and move away from some of the uncertainties that came from the definition in the 1958 Convention. And in this instance, we have all coastal states now being entitled to a continental shelf up to 200 miles. So this is irrespective of whether the true continental shelf, as geologists might understand it, actually exists. So there are countries like Fiji, like Japan, that actually have quite a narrow continental shelf in reality. But that then means that they can claim the continental rise and the continental margin that extends beyond that as within their legal continental shelf. So one of the things this means, for example, just to make it a little bit more real, is for Japan, which has a very narrow continental shelf, it essentially then has what we would otherwise think of as a deep seabed area. And Japan has realized in some areas that there are rare earth minerals and yttrium in what's referred to as ray-rich mud. So this is something that exists beyond the continental shelf area. And so Japan has now been working towards exploiting the ray-rich mud as a way of developing new mineral resources. And Japan can only do this because it has a narrow continental shelf that then leads into this new area. Otherwise, countries have a continental shelf in which they can find oil and gas, and that might extend for a certain distance. Then also under UNCLOS, we have the situation where states that had very broad continental shelves also wanted appropriate recognition in the convention that their continental shelf, their real continental shelf, extended beyond 200 miles. So a process was set up to be able to enable states to make claims to an extended continental shelf, and that falls within UNCLOS as well. Next slide, please. So Article 76 sets out the current definition of the continental shelf and allows for this possibility of extension through a fairly technical formula that's set out in those provisions, and I'm not going to go into the technicalities of that particular definition. I know Clive is laughing, he knows it's a cop-out. But suffice to say that we have a process in place where geologists and people who understand these things far better than me can otherwise determine if there is an entitlement. Next slide. So as we've heard and we've already seen in the maps, the Philippines has gone through this process in 2012 in relation to the Philippine Basin, and now more recently in making a claim off West Palawan as well. So the Philippines made a submission to the Commission on the Limits of the Continental Shelf, which goes through and studies whether there is a basis under the convention to recognise an extended continental shelf, and recommends to a state what its extended continental shelf can be. The coastal state then declares what its outer continental shelf is, in line with the recommendations from the Commission on the Limits of the Continental Shelf, and that becomes final and binding. Next slide. So the mandate of the Commission on the Limits of the Continental Shelf is set out under UNCLOS, and as I mentioned, it goes through the different submissions and comes up with recommendations, but it will not act where there are situations where there is a dispute between states as to their maritime boundaries. So where that is happening, the Commission essentially says, well, we will wait till the states resolve this. Sometimes states will do a joint submission, so they go, well, sure, we don't know exactly what it is, but we would like for you to at least, make a recommendation that an extended continental shelf exists, and we will continue to negotiate with that information to hand. Next slide. So in terms of the rights that states gain over the continental shelf, we have to draw a distinction, which is sometimes difficult to grasp because the words are so similar. But in relation to the territorial sea, states have sovereignty. We talk about coastal states having sovereign rights in relation to the continental shelf and the exclusive economic zone. And we use the term sovereign rights quite deliberately to indicate that it is something less than sovereignty. And that is because other states still have particular rights within these maritime zones. What's important with the continental shelf is that a state doesn't actually have to claim that it has a continental shelf. It exists by the mere fact that it is an extension. That's different to the contiguous zone, and that's different to the exclusive economic zone. States have to claim those particular maritime zones for them to exist. But we don't take that position with the continental shelf. So with a coastal state having sovereign rights, that means that it gets to adopt legislation, and we also know from the work of the International Law Commission and that it was reinforced by an arbitral tribunal established in the Arctic Sunrise case, that states can also exercise law enforcement powers when it comes to exercising rights over the continental shelf. Next slide. So in terms of coastal state rights and other states' rights, because it is sovereign rights, there has to be this balance. So what we talk about instead is that the coastal state must not infringe or take action that is going to result in unjustifiable interference with navigation and other rights and freedoms of other states. So then the question is, well, what counts as unjustifiable interference with navigation? So, the idea being that you're not going to put an offshore platform exactly where one of the main shipping routes is through a particular maritime area. So in terms of the effect that sovereign rights over the continental shelf has on the adjacent waters, we also need to take into account the exclusive economic zone. So next slide. The exclusive economic zone then also extends up to 200 nautical miles from the coast of a state, again measured from the baselines that we talked about earlier. So the EEZ is different to the continental shelf. It does not exist by mere fact of being a coastal state, but any coastal state can make a claim to an exclusive economic zone. And this map kind of shows nicely to what extent areas of exclusive economic zone exist across the Earth. Next slide. So then also when we're talking about the exclusive economic zone, we're also talking about sovereign rights. Once again, it is not an area of sovereignty. Again, so it's this idea of lesser rights than full sovereignty would give a state. So when I talked about the territorial sea this morning, I talked about the coastal state having full criminal jurisdiction or civil rights jurisdiction as set out under Articles 27 and 28. It's a different thing once we get to the exclusive economic zone. Instead, the coastal state has sovereign rights for the purposes of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superjacent to the seabed and its subsoil. So the EEZ is about being able to exploit the natural resources of that area. The oil and gas in the seabed, so it kind of overlays with the continental shelf regime, and importantly, it's all about regulating the fish that are found in the exclusive economic zone. So fishing is a really critical aspect of states claiming rights over the exclusive economic zone, but it goes beyond that because it also references sovereign rights for other activities for the economic exploitation and exploration of the zone. And there's also exclusive jurisdiction for other activities, which is the conduct of marine scientific research in relation to artificial islands and structures, and also in relation to the protection and preservation of the marine environment. So the coastal state has a lot of rights within its exclusive economic zone. Those are all fairly significant activities and are indeed critical for a coastal state's economy. But always there has to be a balance with the rights of other states and their ongoing interests. Next slide, please. So in terms of some of the key rights that exist, in relation to fishing in the exclusive economic zone, UNCLOS goes on and sets out requirements for states, particularly under Articles 61 and 62, about the steps that coastal states are to take to conserve and manage the marine living resources, or the fish, within the exclusive economic zone. So there are a series of requirements around the management of fish stock, references to optimal utilisation and maximum sustainable yield, which these days are kind of somewhat outmoded concepts. We instead sort of have a bit more interest in trying to develop a sustainable approach to fisheries, and the idea of maximum sustainable yield is perhaps seen as not so much in favour of ensuring the long-term survival of fish stocks. But it's up to the coastal state to make these decisions. And the other important thing in relation to coastal state rights over fishing is that the decisions that a coastal state takes over fishing is largely insulated from any kind of third-party dispute settlement proceedings. So in the dispute settlement regime under UNCLOS, disputes relating to the coastal state's decisions over fishing in the EEZ are outside the jurisdiction of a court or tribunal constituted under UNCLOS. Next slide. So also importantly is the coastal state's powers to protect and preserve the marine environment. And there is a whole part of UNCLOS which is dedicated to rules relating to the protection and preservation of the marine environment. It's quite a framework part of the convention. It brings in a large number of other treaties that also deal with the protection of the marine environment. And there's a very broad obligation whereby states have the obligation to protect and preserve the marine environment. That is quite a far-reaching obligation, and it applies in all the maritime areas. But the coastal state has the key responsibilities around that in its exclusive economic zone. Next slide. So Article 194, you don't have to read all the language. It's a lengthy provision, but in a nutshell, what this provision is about is the duty on states to prevent, reduce, and control pollution of the marine environment. So that is an action that states are required to take within their exclusive economic zone, whether it's for land-based pollution or vessel source pollution. And also we now know that the other form of pollution is from greenhouse gases as well. So greenhouse gases are also considered pollution under the terms of Article 1 and falling within Article 194. So a coastal state can adopt laws to reduce greenhouse gases within its exclusive economic zone as part of its powers within the EEZ. Next slide. So also a coastal state has authority over artificial islands within its exclusive economic zone. So Article 60 deals with that particular jurisdiction. What I think is critical to note in this regard is that an artificial island does not give a coastal state maritime zones around that particular feature. So all that can be declared around an artificial island is a 500-metre safety zone, and that is the extent of it. So we do not use artificial islands as baselines or base points, so it does not create maritime zones. But the coastal state instead has powers under UNCLOS in relation to its exclusive economic zone to manage and regulate activities happening in relation to that artificial island. Next slide. All right, so the coastal state has a whole range of different powers and authority within the exclusive economic zone. But as I said, it's all about balancing it with the powers of other states and their authority within the exclusive economic zone. So Article 58 of UNCLOS is the important provision in giving states other than the coastal states rights within the exclusive economic zone. So all states, and really this does include the coastal state as well, has the freedoms referred to in Article 87 of navigation, overflight, and the laying of submarine cables and pipelines and other internationally lawful uses of the sea related to these freedoms. So that language does give some flexibility in terms of what particular freedoms are encompassed within this and what is associated with the freedom of navigation in particular, what falls within the operation of a ship. And that starts getting relevant when we talk about military activities in an exclusive economic zone. So once we start talking about military activities in the EEZ, we have a question of, well, is that something the coastal state can regulate, or is it something that other states have a right to do? So if we look to Article 56, the coastal state has specific rights that has been granted to it in relation to the natural resources, artificial islands, etc. It doesn't refer to it having authority over military activities at all. The problem is when we look at Article 58 and we look at the language there in terms of the freedoms of Article 87 and other internationally lawful uses related to these freedoms, it doesn't explicitly say military activities either. So the Convention doesn't explicitly refer to whether military activities are allowed to happen or not. But the reality is that warships have been sailing the oceans for centuries at this point, and that I do not think it is realistic to possibly suggest that with the creation of the exclusive economic zone that we were now going to be excluding warships potentially from the exclusive economic zone. Of course, they were going to fall within the scope of other internationally lawful uses of the sea. So I do come from a starting position where, yes, military activities by another state can happen within a coastal state's exclusive economic zone, but that doesn't mean it can do any type of military activity and that there's no limits on it. There certainly are. So, next slide. So we need to look at the legal parameters of that. And most critical in this regard is the obligation of due regard. So both the coastal state, as well as all other states, have an obligation of due regard when it comes to their conduct within the exclusive economic zone. So of course your first question would be, well, what does that really mean to show due regard? What is the expectation here? And then it's the great lawyer response of, well, it depends. So it does depend, because some commentators have said, well, by due regard, it means there has to be a consultation with the other state. But I think it actually depends on what activity is going to happen. But in the end, it is a matter of each state taking cognizance of the rights that each other have within that particular zone. So if we take, for example, there was a recent dispute between Russia and Ireland because Russia wanted to go and conduct military exercises in Ireland's EEZ. And the Irish fishers got very upset because they said, no, this is our fishing ground. We need to be in this fishing ground at this time of year, so you cannot do your military exercises here. You need to do them somewhere else. So through that sort of process of negotiation, Russia then moved its military exercises to another area so it would not interfere with this significant fishing ground. But it was a matter of Ireland having to say, no, this is a particular fishing ground, this is the particular season, so this is a really bad time for you to go and start testing, your military maneuvers and whatever in this particular space. So the due regard can involve at least a discussion between states as to what is going on. And that can result in states then changing their conduct. We also have a requirement under UNCLOS in Article 300 that states should not abuse their rights. So again, all right, well, what does an abuse of rights actually look like? So this argument has been made to the different courts and tribunals constituted under UNCLOS in a few different cases. And what the tribunal has usually done is said, well, first we have to see if there is a violation of UNCLOS, and then we say, well, has it been violated so badly as to abuse rights? So that is one potential way to look at this issue. Another is that you look at it in terms of, well, even if there hasn't been a violation of rights, is a right being used in such a way that it is causing hindrance or causing damage, or in other ways that the exercise of this right does not need to be done in this particular way. It's quite a nebulous assessment in some ways. But again, I think it provides another way that states can then use legal arguments to then go and refer to, well, particular conduct that is happening and what are the bounds of that conduct. So what is acceptable? At what point do you go, no, that is crossing a particular line? Also very clear from UNCLOS is that it reinforces the prohibition that we have under Article 2, Paragraph 4 of the UN Charter on the prohibition on the threat or use of force. So there is a particular threshold to establish if there's an unlawful use of force. But I think what comes up more so when we're thinking about military activities in an exclusive economic zone is whether that constitutes a threat of the use of force. So this is something that I have looked into, trying to understand, well, what does it mean to do an unlawful threat of the use of force? If you're actually there and you're testing all these different weapons and you're pretending like you're about to invade a country, does that make it look like an unlawful threat of the use of force? But the legal thresholds to establish it are all quite high in the end. There has to be some element of coercion. There has to be an assessment as to whether if a state actually did the use of force that it's threatening to do, is that illegal in its own right? If you're talking about invading another country, at least you can say yes to that fairly easily. It has to be fairly clearly communicated, and there has to be an immediacy around it as well. So it's not like, well, we're going to pretend to invade your country, and we might do it any day between now and in the next 5 years. There's not an immediacy, but it's an unlawful threat of the use of force if it's like, well, we're going to pretend to invade, and actually that's because it's going to happen next week. Then it does. So the legal standard is difficult, but I think the point I want to make is that the threshold is quite high. I think you've got more basis for arguing that obligations of due regard are potentially being violated. All right, next slide. So when we're considering different military activities, I think the other thing to bear in mind is that there are a whole range of different types of military activities as well. Most commonly, the types of military activities that will be happening in an exclusive economic zone are going to involve intelligence gathering, and sometimes it will be military intelligence research as well. And there is a question that has been debated in the literature about whether military research should be regulated as marine scientific research. And that particular debate matters, remember, because the coastal state has exclusive jurisdiction over marine scientific research. So if the coastal state where the coastal state does have exclusive jurisdiction over marine scientific research, that means that it has to consent to any sort of research happening within its exclusive economic zone. But the argument that is usually put is that military research is not the same as marine scientific research, and that is because military research is not intended to be shared generally with the public. Its purposes are quite different to the usual pursuit of marine scientific research, where you're gathering data, you're trying to establish a hypothesis, you're publishing all your information, and then we gradually gain more information. Military research is about gathering information and keeping it for yourself. So that kind of distinction is usually made and then sort of said, well, because it is not marine scientific research, it is one of these other lawful uses that falls within Article 58. And I think bolstering that particular perspective is the reality that under quite a few different treaties, there are expectations that states will engage in different forms of intelligence gathering. And they will do that to be able to detect crime that might be happening within different maritime areas. So there is some degree of intelligence gathering that must be acceptable because of the different obligations to suppress or prevent different maritime crimes. But as we talked about briefly in the question time before lunch, the advent of maritime autonomous vehicles is also making this assessment a little bit more complicated. Can we go to the next slide, please? So what we're seeing much more with maritime autonomous vehicles are the use of what's more commonly referred to as gliders. So these are two examples of gliders you see in the photos here. The one on the left is the type of glider that the United States was deploying off one of its research ships and that the Chinese then seized. And the US protested vigorously that its glider had been seized, saying that it was the sovereign property of the United States. The United States is not the only country using gliders. The photo on the right is a Chinese glider that was found by Indonesian fishermen. And I like that photo on the right. I use it quite a bit in my presentations because it gives you a sense of the size of these, vehicles that we're dealing with. And I say the word vehicles quite deliberately there because it goes back to that point I was talking about earlier in terms of are these ships or not? Because do gliders enjoy a freedom of navigation? So there's an interesting distinction as well. For the territorial sea, we talk about all ships having a right of innocent passage, but the freedom of navigation is accorded to states, generally. So a state can then decide what it is that it has amongst its equipment, vehicles, ships, that it is going to allow to exercise a particular freedom of navigation. But it gets even more complicated when you start going, okay, well, this one on the left definitely belonged to the US Navy. Probably the one on the right belonged to the Chinese Navy. So if they belong to the Navy, does this mean they're warships? Because if they're warships, then they get sovereign immunity. So then we can look to the definition in UNCLOS of warships, and there is a definition of warships under Article 29. And the definition of warships actually dates back to the 19th century. And it refers to the fact that there are ships that are under the command and are also manned by members of the armed forces. So the definition of warships anticipates that they're under the command and that they're being crewed. So then the question is, well, is this under the command and being crewed by anybody? And you go, well, maybe if they're on the ship and they've got a little remote control, then they are. So then they're warships, potentially. And that then means that as a warship, it is privileged with sovereign immunity. Even if it's not a warship, if it's still a government vessel on non-commercial service, it would still enjoy sovereign immunity anyway. But then you get back to the whole, but is it actually a vessel? Is it a ship? Because if it's not a ship, then it's just state property. And if it's state property, is it subject to sovereign immunity? And then we go, oh, it's okay, we have a treaty that deals with jurisdictional immunity of state property. The problem is this treaty has not entered into force. So I think arguably state property that is used for military purposes, I think it's probably safe to say that it is entitled to immunity and states should not be going around taking the property of other states. But it has been an issue in the practice, not just with between the United States and China, but drones have been seized as well by Iran and in a few other instances as well. All right, so a diversion onto autonomous vehicles, but let's move on. Thank you. So also when we're talking about military activities of different types in the exclusive economic zone, I think one of the key activities we would be talking about, not necessarily just by navies, but of course coast guards and other policing officials, will be law enforcement activities. So a coastal state will have authority to conduct law enforcement in relation to the activities over which it has prescribed laws. So the coastal state can enforce its laws relating to fishing, relating to the continental shelf. It has authority to suspend or require the cessation of marine scientific research. it has law enforcement authority in relation to its environmental laws. But there are also other states that can potentially exercise law enforcement powers within the exclusive economic zone. So if you think about piracy, for example, drug trafficking, migrant smuggling, those types of crimes are not explicitly within the powers of the coastal state. All states potentially have authority to conduct law enforcement, but the catch will always be, can you actually conduct law enforcement against a foreign flagged vessel? So there is a whole regime around that, and I imagine Neil might address that more when he's talking about high seas freedoms in the next session. But the main point I wanted to make is, in relation to law enforcement in the exclusive economic zone, we have to expect that the coastal state is exercising law enforcement powers, and other states are going to potentially be exercising law enforcement powers over particular crimes, over foreign flagged vessels. The problem is that navigational rights can be then infringed upon when you have overzealous law enforcement activities. UNCLOS anticipates that in relation to fishing, because it does have a clause allowing for the prompt release of a vessel upon payment of a reasonable bond. But that kind of setup also exists in relation to pollution, but not more broadly than that. Law enforcement also, of course, gets complicated when it's not certain where an exclusive economic zone necessarily starts or ends for one particular country. But even when there is uncertainty over where law enforcement can happen, there's still, again, general principles of law that still apply to this situation. So next slide. So in any instance of law enforcement, whether it's the coastal state acting against fishing, whether it is another state engaged in trying to suppress drug trafficking or maritime terrorism, we do have expectations and standards in relation to the use of force for maritime law enforcement. Okay, the use of force for maritime law enforcement is directed towards private vessels. Okay, if you're using force against another country's warship, then you might be violating Article 2, Paragraph 4 of the UN Charter. Okay, but when we're talking about law enforcement, it's usually law enforcement against a private vessel. At the very least, if you're taking action, law enforcement, ostensibly action, against another country's warship, at the very least you are violating its sovereign immunity, even if it's not going all the way to a violation of Article 2, Paragraph 4 of the Charter. So when force is being used against a private vessel for maritime law enforcement in the exclusive economic zone, or indeed in any maritime zone, the use of force has to be avoided as far as possible. It should not go beyond what is reasonable and necessary in the circumstances. That kind of aligns with international humanitarian law in any event. ITLOS has also said that considerations of humanity must apply in the law of the sea as they do in other areas of international law. And indeed, once a law enforcement vessel is exercising enforcement authority over another vessel, that or effective control over another vessel, if it has seized a vessel, if the Coast Guard officers have gone onto that other vessel, they are in effective control of that vessel. They also owe human rights obligations to the people on board in terms of due process, avoiding arbitrary detention. All right, next slide. So what the International Tribunal for the Law of the Sea has instead indicated is that what we are looking for with any type of maritime law enforcement is a gradation. You're supposed to give a warning, first of all. You're supposed to do shots across the bow before you actually get to the point of resorting to force against the vessel, and even then, appropriate warning has to be issued, and efforts should be made not to endanger life. Next slide, please. So even if we're dealing with other interactions between states in the exclusive economic zone, then it's also important to bear in mind that we do have rules about navigational safety that are also going to be relevant in moderating state conduct. And it's important that we don't lose sight of these particular rules that we have as well. So even under UNCLOS Article 94, which requires every state to take measures for ships to fly their flags safely, we have the COAL regs, the International Convention on Regulations for Preventing Collisions at Sea. These were referenced in the South China Sea arbitration as well. And so we have the binding treaties, but also non-binding instruments that are also intended to moderate state conduct. So the Code for Unplanned Encounters at Sea, which ASEAN has agreed with China will apply in the South China Sea area. And even China and the US have entered into a non-binding memorandum of understanding to also try and deal with encounters, all designed to try and improve navigational safety. And again, if there's some elements of coordination and cooperation, then that can hopefully be enough to moderate some decisions and behaviours around that. All right, so the exclusive economic zone at the end of the day is a complicated zone in there because it's got extensive authority. But other states have rights in that area as well. So really the ultimate challenge is figuring out how to balance the exercise of rights by each of the states involved. So I'm going to leave it there and hand over to my colleague for the Philippines perspective. Thank you.
Continental Shelf, may we call in here on stage Attorney Ana Cosme from the University of the Philippines Institute for Maritime Affairs and Law of the Sea.
Hi, good afternoon. First, I would like to thank the WPS Foundation for the opportunity to speak before you today, especially that it is truly an honor to be part of this panel and to speak alongside distinguished Law of the Sea experts, many of whom I have long looked up to. And of course, thank you to Professor Natalie Klein for that in-depth discussion of the legal regime and legal framework governing the exclusive economic zone and the continental shelf. So, while Professor Klein had laid out the doctrinal foundations under the Law of the Sea Convention, so my task now is to situate these concepts within the Philippine context. Next slide, please. So first we will discuss the Philippine Exclusive Economic Zone. Next slide, please. Okay, so if we can see on the map here, as a mid-ocean archipelago, so the Philippines occupies a pivotal position at the intersection of the Pacific Ocean in the eastern portion, the South China Sea in the western portion, and the Celebes Sea in the southern portion. On the eastern side of the Philippines, facing the Pacific Ocean, we can notice that there are no nearby coastal states. Therefore, there are generally no issues of overlapping maritime entitlements. In contrast, in the western portion, particularly in the South China Sea, the Philippines is very close to several neighboring states, and because of this, maritime entitlements often overlap and disputes may arise. Next slide, please. As discussed earlier by Professor Batong Bakal, while claims to the extended exclusive economic zone began to emerge in state practice in the 1970s, it is only formally defined under the 1982 United Nations Convention on the Law of the Sea. However, the Philippines, even prior to the enactment or entry into force of the 1982 Law of the Sea Convention, the Philippines is one of the first nations to declare an exclusive economic zone through the Presidential Decree number 1599 on June 11, 1978. Basically, the decree declared an exclusive economic zone in conformity with the ongoing text, in conformity with the ongoing EEZ provision aligned with the ongoing negotiations at that time. Next slide, please. So there we can see that under Presidential Decree number 1599, the Philippines already declared the exclusive economic zone to a distance of 200 nautical miles from the base, beyond and from the baselines from which the territorial sea is measured. Next slide, please. It also declared the rights that, as we all know, are already embodied in the 1982 Law of the Sea Convention. Next slide, please. Similar to the freedoms and rights recognized under the 1982 Law of the Sea Convention. Next slide, please. However, in one section, it further explicitly declared that resource-related activities such and construction of artificial islands and installations and other activities falling within the sovereign rights and jurisdictions of the Philippines were limited to Filipino citizens, and any other person would be only allowed to do so under the terms of a prior agreement with the Philippines or a license granted by it. Next slide, please. So after several decades, so of course we knew that under the 1982 Law of the Sea Convention, the EEZ was formally established and that the Philippines is a party to that convention. In 2012, in view of the ongoing disputes in the South China Sea, to further affirm the Philippines' rights over the West Philippine Sea, President Benigno Aquino III issued Administrative Order number 29, series of 2012, to officially name the western portion of the Philippines as the West Philippine Sea. So, however, it only named it, but it did not explicitly define under that administrative order the extent or the distance up to which the West Philippine Sea is measured. Under Section 1, it only said that the maritime areas on that the West Philippine Sea covers the maritime areas on the western side of the Philippine archipelago, and that these areas include the Luzon Sea as well as the waters around, within, and adjacent to the Kalayaan Island Group and Bajo de Mansinloc, or also known as the Scarborough Shoal. Although even though it did not specify the distance or the extent, it is safe to say that the West Philippine Sea, of course, covers the territorial sea, the EEZ, continental shelf entitlements of the Philippines under the 1982 Law of the Sea Convention, and of course, and the possible extended continental shelf claims in the Western Palawan region. Next slide, please. In November 2024, the Philippine Maritime Zones Act was enacted, and of course, the Philippine Maritime Zones Act affirmed the Philippines' rights and obligations under UNCLOS. Section 7 provides for the EEZ, and basically it says that the EEZ of the Philippines refers to the waters beyond and adjacent to its territorial sea and up to 200 nautical miles from the baselines. But it also adds a provision that says all other low tide elevations within 200 nautical miles from the archipelagic baselines shall likewise form part of the EEZ. Next slide, please. Okay, so again, it affirmed the rights and obligations and the Philippines' jurisdiction over its EEZ. Next slide, please. But I'd like to refer you to the South China Sea arbitration. So we know that in July 2016, the arbitral tribunal under Annex 7 provisions issued an award regarding the South China Sea arbitration. It clarified, one of the things that it clarified was the status of the different maritime features in the South China Sea. It ruled that the Philippines is entitled to a full 200 nautical miles of EEZ and continental shelf, and this continental shelf can extend beyond 200 nautical miles. Under the South China Sea arbitration, five out of 12 submissions of the Philippines asked this arbitral tribunal to clarify the status of some of the maritime features in the West Philippine Sea. Next slide. So basically, this is a summary of the ruling with respect to the clarification of some of the features. So there's the Mischief Reef, which in locally we call Panganiban Reef. It is classified as a low tide elevation, and it is located within 200 nautical miles from baselines. Also, the Second Thomas Shoal, or the Ayungin Shoal, where BRP Sierra Madre is currently posted, is also a low tide elevation located within 200 nautical miles from baselines. And there are the other maritime features, such as the Subi Reef, the Scarborough Shoal. Next slide, please. The Hughes Reef, Gavin Reef, North and South, Corcoran Reef, Fiery Cross, Johnson Reef, and the McKinnon Reef. Some of which are, even though located within the 200 nautical miles from baselines, are rocks. So it doesn't, if we go back to the provision on the EEZ under the Maritime Zones Act, it's not qualified under that provision. And some features are rocks, which some lie within the 200 nautical miles from baselines, and the others lie outside of the 200 nautical miles exclusive economic zone. So later, I will not discuss in depth what the low tide elevations or the implication of whether a maritime feature is a low tide elevation or a rock or an island. I will leave that to Professor Schofield later to discuss. Just to note, a previous slide, please. Just to note, like, for example, Mischief Reef is a low tide elevation and Second Thomas Shoal, and both are within 200 nautical miles from baselines. Although one important thing to note is that a low tide elevation is not capable of appropriation, unlike islands or rocks. Oops. Sorry, next slide, please. Okay, another issue with respect to the EEZ of the Philippines is the delimitation with EEZ delimitation with Indonesia. So Philippines and Indonesia commenced negotiations on the overlapping exclusive economic zone in 1994. In 2014, they have signed this agreement, and in 2019, they made an official joint submission to the UN of the Maritime Delimitation Agreement. So this EEZ, next slide, please. So this is the final delimited line between the Philippines and Indonesia. So it is an overlap in the Mindanao Sea and Celebes Sea, and in the southern portion of the Philippine Sea in the Pacific Ocean. Next slide. So now we turn to the continental shelf history and relevant Philippine context. Next slide, please. Professor Klein earlier discussed the Truman Proclamation in 1945. In 1949, the Philippines enacted Republic Act number 387. It basically adopted the Continental Shelf Doctrine contained in the Truman Proclamation in 1945. It also did not provide for the extent, as it focused more on the state ownership of the resources and laws on the exploration and exploitation of the natural resources therein. Next slide, please. In 1968, the Philippines, then President Marcos issued Presidential Proclamation number 370, or the Revised Continental Shelf Claim of the Philippines. So, I forgot to highlight it, but there's this part on the third line, to where the depth of the superjacent admits of the exploitation of such resources. So as mentioned by Professor Klein also earlier, it is depth-driven and also technology-driven. So it somehow raised an issue to which this claim to a continental shelf is not based on a fixed measure, but rather on the state of technology that keeps on going and changing. Next slide, please. So again, after decades, in 2024, again, we have the Philippine Maritime Zones Act. It also contained provisions on the continental shelf. And next slide, please. It explicitly mentioned our extended continental shelf claims, such as the Benham Rice region, which includes the Philippine Rice, and it changed the name so from Benham Rice to Philippine Rice, and it then changed the name to Talampas ng Pilipinas. As well as a provision that the Maritime Zones Act is without prejudice to the submission for an extended continental shelf in the West Palawan region. Because at the time that this was enacted, the Philippines already made its submission before the Commission on the Limits of the Continental Shelf in 2023. Next slide, please. So again, it just affirmed all the rights and obligations in the continental shelf under UNCLOS. Next slide, please. So again, so the first partial submission of the extended continental shelf pertains to the Philippine Rice, so in the Benham region. So this Philippine Rice is on the eastern portion of the Philippines, in the facing the Pacific Ocean. This Philippines made its partial submission of the extended continental shelf on April 8, 2009. That's just 1 month before the deadline set by UNCLOS for the submission of information on the outer limits of the continental shelf. And in 2012, the UN Commission on the Limits of the Continental Shelf adopted the Philippines submission for its extended continental shelf. So, because politically, it is easier to have it approved and adopted, because as I've said earlier, in the eastern portion, we don't have close neighboring coastal states that have overlapping jurisdictions over the continental shelf. So, according to, this is the first successful validation of a claim by the Philippines in accord with the 1982 Law of the Sea Convention. And this is the first also major expansion of the Philippines' maritime boundaries since the late 1970s, when it declared its EEZ. Next slide, please. So again, as has been provided for under the Philippine Maritime Zones Act in 2017, the Benham Rice was renamed officially to Philippine Rice, and in May 2018, a proclamation was issued to declare a portion of the Philippine rice as a marine resource reserve. According to scientists, the Benham rice contain abundant fishery resources as well as untapped natural gas and heavy metal deposits. Okay, I was told I only have 3 minutes left. I'm close. Next slide, please. In 2019, scientists discovered a Polaki caldera, and at the time, and up until this time, it is identified as the world's largest caldera. A caldera, it is a volcanic feature formed by the collapse of a volcano into itself, making it a large special form of volcanic crater. The discovery was made by a team of marine geophysicists, including a Filipino named Miss Jenny Ann Barreto. And again, in 2024, it has been collectively renamed as the Talampas ng Pilipinas. Next slide, please. Just to honor the team that made this submission successful, there's a team, and to refer to questions about Benham rice later to them. No, I'm kidding. Next slide, please. Okay, so as has been mentioned earlier, the Philippines made a partial submission of an extended continental shelf, this time in the Western Palawan region. Of course, this submission is without prejudice to future delimitation of the limits of the territorial seas of individual high features in the South China Sea. Unlike the submission for the Benham rice, the submission of the extended continental shelf claim in the West Palawan region has been met with oppositions officially by China and Malaysia. According to China, it claims that it is a unilateral submission of maritime boundary delimitation of the continental shelf, and it infringes on their sovereignty. For Malaysia, considering they are opposing it because the continental margin on the southern portion is projected from the baselines of Sabah, which we know is subject of territorial dispute. A month later, previous slide, just one more. Vietnam did not officially oppose this submission, but a month later, they also submitted their own claim to an extended continental shelf, which overlapped with the Philippines' claim. Next and last slide. So, following the successful delimitation agreement in the exclusive economic zone with Indonesia, as mentioned earlier, on the 5th of October 2022, PH and Indonesia signed the principles and guidelines for continental shelf delimitation, and is currently and the negotiations for such delimitation agreement is still ongoing. So I will stop there. Thank you very much.
Thank you so much, Attorney Cosme. And now, we are now down to the question and answer portion. And with that, may we invite again here on stage Professor Natalie Klein from the Faculty of Law and Justice of the University of New South Wales, Sydney. Together with her is Attorney Anna Cosme from the University of the Philippines Institute for Maritime Affairs and Law of the Sea. Again, we are now down to the question and answer portion.
Yes, Mr. Salpe.
Thank you very much for your presentations. I have a question for Professor Klein, and just another info added to the discussion of Attorney Cosme. My question for Professor Klein is that how can how can a coastal state legally resolve suspicious military activities occurring in the EEZ of the coastal state by highlighting due regard obligation? That's my question. And then just additional info from to the presentation of Attorney Cosme is that I believe some of the legal educators that I have met with are confused when we submitted an extended continental shelf to the West Palawan region, because I've heard that some equate extended continental shelf as also being extended the EEZ. So I'd like to clarify that extended continental shelf is not extended EEZ, because above the extended continental shelf, the water column still remains as the high seas, subject to freedom of navigation and flag state jurisdiction, not coastal state jurisdiction. Another is that the Philippine submission to an extended continental shelf at the West Palawan region is still pending before the Commission on the Limits of the Continental Shelf, or CLCS, due to its overlapping claims, as mentioned earlier, with other coastal states, such as Vietnam. Vietnam submitted a statement which resolutely rejects this claim by the Philippines. This means that the West Palawan extended continental shelf claim is still an area beyond national jurisdiction, not yet an area within national jurisdiction. Because technically, if we look into the provisions as per Annex 1.5a to the Rules of Procedure of the CLCS, in cases where a land or maritime disputes exist, the CLCS shall not consider and qualify a submission made by any of the states subject or concerned in the said dispute. This means that the Philippine submission to an ECS, or Extended Continental Shelf, is tabled by the CLCS until such overlapping maritime claims have been delimited already. Thank you.
Well, first of all, in relation to suspicious military activities, a coastal state would need to communicate with the state concerned to find out what activities were being undertaken. And in an assessment of due regard, it would also be a question of the coastal state making an assessment as to whether any of its rights were being infringed by the activities that are being undertaken. Is it in a fishing ground? Was there a marine scientific research program scheduled to happen that cannot happen because of the military activities? So in the end, I think due regard requires dialogue between the states concerned to be able to understand exactly what the stakes are and what interests are potentially being infringed, if at all, because remember when we're talking about the exclusive economic zone, it can be up to 200 nautical miles. So it's a very large area, and there's often enough space for everyone to share. So you'd want more information about what the military activities are, and also what interests or what rights the coastal states has that are being prejudiced by those particular military activities. So a dialogue would be essential. But there's also a possibility of referring to the dispute settlement processes to challenge military activities that are considered to be a violation of the due regard obligation, subject to whether a state has excluded military activities from compulsory jurisdiction.
Thank you very much.
Okay. Also, if I may address the latter additional information. So thank you for that. So as I've mentioned earlier, the submission for the extended continental shelf in the West Palawan region is still ongoing. It is not yet adopted. And also, Dr. Batong Bakal has mentioned earlier that it's potentially not going to be adopted, or it's going to take a very long time because of the presence of disputes. And that, again, China and Malaysia have formally opposed this submission, and Vietnam has made their own submission. And also with respect to the confusion on the extended continental shelf, so under UNCLOS, as has been extensively also discussed by Professor Klein earlier, that it is possible to have unlike the continental shelf, up to 200 nautical miles, which is an inherent right of a coastal state. An extended continental shelf is something not the Philippines, a coastal state need to claim for and prove using the technical provisions. There's the depth and other scientific things that I will leave to the geologists. So, but once a coastal state has satisfied those conditions, they can submit a claim to the Commission on the Limits on the Continental Shelf, and then it will be deliberated. And then, if no further disputes, or if it's sufficient in form and substance, then they will approve it. Just like what we had in the Benham Rice region. So, thank you.
Thank you. There's a question from Isaac. Ms. Isaac?
Yes, hello, good afternoon. My name is Bryn Isaac. I'm from the Philippine International Law at Sea Academy. So I have one question. Perhaps both of our experts on the floor could answer it. So the UNCLOS grants coastal states sovereign rights over resources in the exclusive economic zone, but grants all states the freedom of navigation and overflight. And in the West Philippine Sea, we frequently see foreign coast guards and maritime militia operating under the banner of freedom of navigation, while simultaneously interfering with our resource exploration. So the question is, like, where is the precise legal line where freedom of navigation becomes an unlawful infringement on a coastal state's sovereign rights?
Oh, I hate to say the same thing again, but it will depend. In terms of at what point is it an infringement on those particular activities, if there is a foreign state's coast guard operating in an exclusive economic zone of another country that has the effect of denying the fishing rights, then it is clear that that activity is unlawful. That situation arose precisely before the International Court of Justice in the case between Nicaragua and Colombia in relation to the alleged violation of sovereign rights, where Colombia was purporting to exercise law enforcement powers in an area that was considered Nicaragua's exclusive economic zone. Of course, the difficulty that we have within the West Philippine Sea is that there isn't a final delimitation of the maritime areas, and that remains disputed. But even in a situation where there are disputed maritime zones, states still have to operate under, principles of restraint, non-aggression, non-abuse of rights, still showing due regard as well. So again, it would have to be looked, but I think at the point that it is a clear interference and a prevention of the exercise of rights, then it seems clearer to me that that is going too far across the line, whatever that line might exactly be.
So maybe just to add to that, but in the Philippine context, we also, aside from the due regard provisions or the obligations under UNCLOS, there's also the fact that the Philippines have won the 2016 South China Sea arbitration, but this award has been consistently and continuously been not accepted and not recognized by China. So I just want to share. So I went to the West Philippine Sea for a marine scientific research in 2024 with scientists to conduct marine scientific research, and Escoda Shoal in particular. So while we were there, Chinese Coast Guard plenty of Chinese Coast Guard ships were there, maritime militia vessels were there, and then when we were conducting our marine scientific research, they would chase us with we were in small rubber inflatable boats, and they would chase us with their huge Philippine Coast Guard vessels, their choppers, and they would interfere with our marine scientific research. And they would get near us, they would explicitly tell us to get off Sabina Shoal, and they would claim, this is China Sea, this is China Sea, please get off, you have no right to be here. So, of course, so there's that. Aside from explicit violation of the arbitral tribunal or non-recognition of the arbitral tribunal, they're very, very adamant in their claim that that portion of the South China Sea is theirs. So.
At this point, we'll pause for a while for the Q&A. And please reserve your questions later after the presentation of Professor Neil Simon Silva. May we request now Professor Neil Simon Silva for the part 2 of this session 3, focusing on the high seas and freedom of navigations. To Professor Klein and Attorney Cosme, may we request to please remain on stage. Thank you.
Um, Good afternoon, ni hao. Sorry, to be formal, way ni hao. Okay, this is a presentation concerning high seas and other common areas. Now, the remit given to me was to discuss high seas and also freedom of navigation related to the high seas, but also to discuss RFMOs. Now, I only have 40 minutes, so I've had to cut down. I spent several hours cutting down 150 slides to around 50, 55. I'm not sure if that's still enough, but I will try. By the way, I am a poor substitute for what should have been the foreign speaker. I hope I will do justice to the topic. I would like to acknowledge the assistance of our research assistants who are named in the first slide. Next slide, please. Okay, first, everything I say here are my opinions. So they're without prejudice to the consideration of more learned people, including, I hope, for the correction of Dr. Schofield and Dr. Natalie Klein. In case there's any error, I would be honored to be corrected by you. Next slide. So before we begin, I would like to make a distinction because some of the questions need, I suppose, in view of the questions, this clarification must be made. We must make a distinction between these issues. Are we asking about objective realities? Are we talking about ethics, including international ethics? That's relevant. That's why we call rules-based order and not only international law, because a lot of the rules are actually ethical or political in character. Are we talking about domestic law or municipal law? Are we talking about public international law? We need to distinguish also from the question of policy, from the question of optics, and from the question of security. Because these are important to distinguish. Because, for example, UNCLOS, while it is partly responsive to security concerns, does not necessarily reflect only the security concerns of coastal states. Because if you were to respond to the security concerns of coastal states, you would agree with China that you can turn the EEZ into a security perimeter, given the range of beyond visual range missiles today. So we need to distinguish these dimensions every time we're discussing these topics. Next slide. So we will have several, there are a lot of parts here. The first one is scope. What do we mean? What are we going to be talking about? Next slide. Now, I would like to note that, as noted by Professor Oxman, what distinguishes the high seas provisions of the UNCLOS as opposed to the 1958 Convention of the High Seas is that the wording of the UNCLOS doesn't define the high seas. It only defines the application of the high seas provisions. Next slide. Because we are talking about different things. For example, the high seas provisions of UNCLOS, insofar as the non-fisheries provisions are concerned, are limited to the high seas proper, which is the area outside the EEZ, and territorial sea and internal waters. But when we're talking about the fisheries provisions are only limited to the area outside the EEZ. But the freedom of high seas provisions, high seas freedoms, actually apply also in the water column of the EEZ. Now, when it comes to the seabed provision, it applies, as noted, to the area, which is the area outside the continental shelf and as extended in accordance with Article 76 of UNCLOS. And when it comes to BBNJ Treaty, we're talking about the international seabed area plus the water column outside the EEZ. And finally, when it comes to the high seas under Chicago Convention, which according to the footnote of Bernard Oxman, Professor Oxman, is one of the reasons why they worded the UNCLOS in that manner, airspace basically is all the airspace outside the territorial sea. So we have to ask, therefore, what do we mean by the high seas? Because if you look at the chart, therefore, the high seas there, as far as the water column is concerned, as defined under Part 7, is everything right of the EEZ. However, the high seas freedoms provisions of Part 7 are actually applied to the EEZ as well. So we need to make a distinction. So from now on, we will be navigating those distinctions. Next slide. So why is that relevant for us? Because of the donut hole in the South China Sea. Now, the donut hole in the South China Sea, the water column is high seas proper. However, the seabed is subject to multiple overlapping extended continental shelf claims. So what is the high seas proper? The water column of the donut hole. But to what areas do high seas freedoms apply? To the donut hole and the EEZ of the different states, except for the fisheries and natural resources provisions. So, next slide. Also, same thing with the Philippine Rise, by the way. If you look at Philippine Rise, because of the 2009 submission and now the 2012 notification of its extent, now we have jurisdiction and sovereign rights over the seabed, but again, the water column remains high seas as defined under Part 7. I say the high seas as defined under Part 7 because, again, there's a different high seas under the Chicago Convention. Next slide. So, now, so there are several parts. First, we're going to talk about high seas freedoms and allocation of jurisdiction. And then we will briefly talk about marine environmental protection. And then we will talk about management of the living resources. And then we will talk about management on non-living resources under the international seabed area. And finally, options for the Philippines. Somehow we will do that within 40 minutes. Okay, next slide. So, very important to note is the distinction between what you call prescriptive or rule-making jurisdiction and enforcement jurisdiction. Please, the first thing we have to do is disabuse ourselves of the idea that the high seas freedom are somehow a regulatory wild, wild west. They are not. They are subject to overlapping regimes. There are problems as to the enforcement of those regimes because of the flag state, exclusivity of flag state jurisdiction in many ways. But there are many overlapping regimes, including on the environment, on living resources, and non-living resources. Now, next slide. For example, who has the power to enforce? It depends. For the most part, it's the flag state. However, there is limited port state jurisdiction, as I will discuss under environment. And there's limited jurisdiction and enforcement powers in the high seas, particularly the right to visit, as well as limited rights insofar as piracy is concerned, as well as suppression of unauthorized broadcasting. So, next slide. Now, this is basically a summary of the regime of the high seas. In case I don't have time to go to the other slides, this is basically a summary. What are the high seas freedoms? As earlier adverted to by Dr. Klein, you have freedom of navigation, overflight, freedom to lay submarine cables, freedom to construct artificial islands, freedom of fishing, and freedom of scientific research, which is, and then But what are the norms? As I said earlier, number one, it's really the primacy of flag state jurisdiction. Number two, cooperation among states to suppress slave transport, piracy, unauthorized broadcasting, and illicit drug traffic. A limited right to visit, and also a right to hot pursuit, as will be discussed. Next slide. So, I will discuss freedom of navigation and flag state jurisdiction because they are linked. If you look at the wording of freedom of navigation, every state has the right to sail ships flying its flag in the high seas. So, flag state jurisdiction has primacy. Every state shall sail under the flag of one state only, except in exceptional cases. For example, if there was a change in ownership, and a state which attempts to fly under two flags is deemed to have no flag at all, right? Insofar and cannot assert either flag vis-a-vis other states. And warships and government vessels in non-commercial service are completely immune from jurisdiction. Next slide. Now, what does this mean? Now, these are some slides borrowed from Dr. Batong Bakal. Number one, they have regulatory jurisdiction. Next slide. And then, among others, for example, it is the flag state that will determine, for example, the seaworthiness of vessels, their manning, the survey and classification of vessels. Next slide. And it is, when it comes to enforcement jurisdiction, it is the flag state that has the primacy when it comes to the right to investigate vessels. If you go through UNCLOS, and I second Dr. J's recommendation to do so if you have insomnia, read UNCLOS. You're going to see a lot of times the words that if a state has concerns that a particular vessel is not following the law, it will report it to the flag state. And it will be the flag state that has the primacy of enforcement. And that's why it will cause an inquiry into every marine casualties. And in case there's a question of criminal jurisdiction over a collision, and there's a question of criminal jurisdiction over the master of the vessel, it is the flag state, and secondarily, the state of the nationality of the master that would have jurisdiction over criminal cases over that particular collision. Next slide. Yeah, that's all for penal jurisdiction. Next slide. Now, there is a limited right to visit available to other states. For example, if they have grounds to believe that the vessel is engaged in piracy, drug traffic, unauthorized broadcasting, or slave trade, or it is flying without nationality, or it is flying a foreign flag or refusing to show its flag, when in fact it is of the same nationality as the warship. Next slide. Now, a major component of the jurisdiction in the high seas, which is not flag state jurisdiction, is that states must cooperate in the suppression of piracy. Piracy is considered one of the few offenses that is subject to universal jurisdiction, such that any state may assume jurisdiction over cases of piracy. Next slide. What do we mean by piracy? This is on the left, you can see the definition of piracy under UNCLOS, which is any illegal act of violence committed for private ends by the crew or the passengers of a private ship or private aircraft. Now, although that's somewhat modified by Article 102, in some cases, a government vessel which is taken over by its crew may be assimilated to a pirate vessel. Now, I would like to contradistinguish that with the definition of piracy under Philippine law, which is first under Revised Penal Code, Article 3815, where it defines piracy as the act of any person who shall attack or seize a vessel, or not being a member of its complement or a passenger shall seize whole or part of the cargo of said vessel. Now, contradistinguish this again to another provision of the Philippine law, which is Presidential Decree 532. Note that Presidential Decree 532 mentions acts on Philippine waters, whereas Article 3815 mentions in the high seas. However, our Supreme Court has said that high seas does not mean high seas in the sense of outside jurisdiction, but rather high seas means merely of a great distance from the coast. So, therefore, that is an issue, of course, when it comes to asserting jurisdiction over the over the offense, because as you know, under the principle of legality, we have to prosecute for an offense that's actually written in our municipal law. Next slide. Now, one aspect of enforcement jurisdiction is the right to hot pursuit. What is hot pursuit? Hot pursuit is the pursuit of a perpetrator vessel that is initiated within the coastal state's jurisdiction and is continually pursued up to the edge of the territorial sea of another state. You cannot exercise hot pursuit to be into the territorial sea of another state. Basically, you can exercise it up to the EEZ of that state, but not its territorial sea. Now, hot pursuit can be initiated from the territorial sea or from the contiguous zone for acts related to the enforcement jurisdiction of a state in the contiguous zone, meaning customs, fiscal, immigration, or sanitary cases, or within the EEZ for matters which are subject to the jurisdiction of a state in the EEZ. Subject, of course, to the caveat that even within the EEZ, there is still flag state jurisdiction. Now, that is why there are 3 arrows, one from the territorial sea, one from the contiguous zone, and one from the exclusive economic zone. Now, note that it is hot pursuit if it's continuous, and it has to be initiated by the aircraft or the vessel, not only citing the perpetrator vessel, but actually warning the vessel and communicating it and ordering it to stop. So if, for example, I'm a plane and I see a vessel, that's not enough. I actually have to communicate to it and instruct it to stop. And if it refuses to stop, and then I can chase it. And then if I run out of fuel, another ship can, in an unbroken way, take over the pursuit up until the edge of the territorial sea of another state. Next slide. Okay. Very briefly, protection of the marine environment. Next slide. Now, protection of the marine environment is very important because, the ecology does not follow national jurisdictional borders. I have not heard of a case where a endosulfan molecule desisted from entering the EEZ of another state. As a consequence, if we are interested in protecting our ecology, we also need to see to the protection of the high seas as well. And whose jurisdiction is it primarily? It is primarily, when it comes to regulatory jurisdiction in the high seas, it is subject to a lot of international treaties, but the enforcement jurisdiction is primarily, although not only, the task of the flag state. It is the flag state that has primacy of jurisdiction as to the acts of pollution committed by ships registered with the flag state or aircraft registered with the state of registry. This is actually relevant because there have been legal developments concerning the implementation of Article 194, specifically in regard to climate change. There have been advisory opinions by the International Tribunal on the Law of the Sea and the International Court of Justice as to whether or not that obligation is impacted by climate change. Meaning, do states have the obligation to prevent the release of anthropogenic climate change-causing chemicals, substances including, but not limited to, for example, carbon dioxide and carbon monoxide and methane, because those are considered as pollution. Now, the ITLAWs and the ICJ have both said yes, because you have to take into account the development of the norm from the signing of UNCLOS 1982 to the eventual development of international law, which includes the Paris Convention, which now considers that the release of carbon dioxide, carbon monoxide, and other greenhouse chemicals may be, in its amount, an act of pollution. Because the definition of pollution is the release of harmful substances harmful to the environment. Now, I must say for the record that from an ethical and policy perspective, I do agree with these decisions, but from the perspective of positive legality, I have reservations as to whether or not they amounted to sort of legislation by the tribunal. I am not certain. But from a moral and ethical perspective, this is actually a good decision to basically assert that states have the obligation to have the obligation under UNCLOS to cooperate on the suppression on minimization of climate change, anthropogenic climate change. Next slide. Now, this is actually an issue for also, note that when it comes to pollution, maritime pollution in the high seas, there is a sharing of enforcement jurisdiction between the flag state and other states. For example, look at this, let's just exercise this scenario. Since I think many people are lawyers here or operators, then a scenario would be appropriate. Let us say you have a vessel flagged with state A, which spills a chemical, which spreads to the EEZ of state Charlie, C, and then that vessel goes to the port of state B. Who has jurisdiction, enforcement jurisdiction, insofar as the act of that vessel is concerned? From the provisions of UNCLOS, next slide, it would be primarily state A, because state A under Article 217 as the state of registry or the state of the flag state, it would have primary jurisdiction to enforce laws and laws made in accordance with international standards concerning protection of the marine environment for pollution are the jurisdiction of state A. However, if we noted from the example, the pollution, the spill has spread to the EEZ of state C. So when vessel goes to the port of state B, state C can ask B to take steps to inspect the vessel and conduct other enforcement measures. Next slide. And that's actually under UNCLOS, under Article 218. When the vessel is voluntarily within a port, a state may undertake investigations and institute proceedings in regard of any discharge, provided that it must do so only if, for example, if the state affected, state Charlie, state C, has made the request. So there is an apportioning, limited sharing of jurisdiction, not only the flag state, but also the port state. Next slide. So now let's go to management of living resources. I don't know if I'm still within time. Okay. Management of living resources is subject to what we call freedom of fishing. This is again a slide from Dr. J. Batong Bakal, where it states basically, okay, there's basically freedom of fishing, but it's freedom subject to rules. Okay? And then basically, all states have the right for their nationals to engage in fishing in the high seas, subject to treaty obligations, and the duty to cooperate, the duty of coastal states, as well as the states whose nationals are exploiting the living resources to cooperate in the conservation and management of the fish stocks in the area. Now, we must make a note that there are different, as I said earlier, it is not true that the high seas are not subject to any legal regimes. What they are subject to is multiple legal regimes. Next slide. For example, when it comes to anadromous stocks, which, if I remember correctly, are species that spend most of their lives in the high seas, but would spawn within the jurisdiction of a coastal state. I tend to reverse anadromous and catadromous. There's a general rule that you are not allowed to fish for them in the high seas, subject to some exceptions, when it will cause economic dislocation of a state other than the state of origin, right? When it comes to catadromous species, these are species that spend most of their lives inside the national jurisdiction of the coast state, but will spawn, for example, in the high seas. Again, if you notice, it's a prohibition. You are not allowed to fish for them outside the EEZ. Next slide. Now, when it comes to highly migratory species, next slide. When it comes to highly migratory species, then it requires cooperation between the coastal state and the states which are, for example, whose nationals and vessels conduct fishing for the species. And when it comes to marine mammals, states must cooperate and may, in fact, impose standards higher than that provided under UNCLOS. When it comes to marine mammals, of course, we mean whales and other cetaceans. Next slide. Now let's focus on highly migratory fish species, which are subject to a specific implementing agreement called the 1995 Fish Stocks Agreement. It covers and it governs not only the behavior of the flag states of fishing vessels, but also of the coastal states proximate to the area where the fish stocks are and where they travel. Next slide. So it applies to straddling and highly migratory fish stocks. And what are the obligations of states? Essentially, when it comes to the fish stocks, they must cooperate in ensuring the long-term sustainability and conservation of these target fish stocks, as well as of associated species which are dependent on or on which those fish stocks may be dependent. Right? They have to cooperate, and although, of course, remember, fish don't carry passports, right? And they don't ask permission. So they travel from the high seas to the EEZ, right? What happens, for example, when you have measures in the EEZ of one state, measures EEZ of another state, and measures also compatible with in the high seas? You need to ensure that those measures are compatible, and you must cooperate in ensuring that compatibility through the relevant RFMO, or Regional Fisheries Management Organization. Next slide. Now, thing is, RFMOs are a very important implementing tool, because states have a duty either to become members of the RFMO, or Regional Fisheries Management Organization, or to abide by the standards and conservation measures made or established through that RFMO. And if you are not a state that is a member of the RFMO, or you are not a state which is complying with the standards, with standards and conservation measures of the RFMO, your nationals, your vessels are not allowed to fish in the area under the jurisdiction of the RFMO. Now the question is, how do you enforce this? Next slide. Okay, sorry. This is a map. Okay, I was told to end. I will have to extend by about 5 minutes. Now, okay, we're okay. It's already. I was told to end around 15:15, and it's 15:14. Okay, I'll extend a very little. Okay, so this is a map of the RFMOs. Incidentally, we should be subject to our RFMO, but political sensitivities have prevented application of the RFMOs to the South China Sea. Next slide. Now, how do you enforce this? Number one, you have the 1993 Compliance Agreement, which, for example, allows a state to, by which states, for example, have the obligation to ensure that vessels flying their flag do comply with the relevant conservation measures. Next slide. And mabilis na lang. And then you have the IAUF Plan of Action of the Food and Agriculture Organization, as well as the 2009 Port State Measures Agreement. Now, note that they refer to IAUF, but you look at the definition of IAUF, it includes violation of the conservation and management measures, or fishing by a vessel which is flagged with a state which is not a member of an RFMO and not complying with the conservation measures of the RFMO. Now, one of the enforcement mechanisms in theory would be the Port State Measures Agreement, to which the Philippines is a party, which obliges states to exchange information and, based on that information, to decide whether they will deny entry to a vessel that may be perpetrating IAUF, or to deny the use of port services for that vessel. Next slide. Okay. Don't have time. So very fast. Let's just very, very fast. The second, double jeopardy. Next slide. Management of non-living resources. Note, UNCLOS was a package deal, quote unquote, which means it was a compromise, and honestly, from the Philippine perspective, an unhappy compromise among various states and interests, including developed countries and developing states. Now, developing states championed an international seabed area regime, which is very stringent. And the developed countries refused to abide by that regime, and it was one of the reasons why a lot of them initially refused to sign on to UNCLOS. Imagine this. One of the provisions of the regime, of the annex, if you look at the annex, it actually says that developed countries are required to give technology to developed countries and to the enterprise, and it doesn't, and basically it's required to give the technology, and it doesn't talk about market costs. And to be honest, if I were a developed country, I wouldn't sign it either. Now, to rectify this problem, they signed a 1994 implementing agreement, which amounted to an amendment, or a revision, in fact, of Article 11 of Part 11 of UNCLOS. Next slide. Okay, next slide. Okay, so just next slide. Note that the geographical extent of the area is everything um, outside national jurisdiction, meaning outside the extended continental shelf. However, this geographical extent is affected by several additional factors. Next slide. Number one, of course, the ECS. If you delimit ECS, you are in fact taking area away from the international seabed. Number two, how do you apply Article 121.3? Do you apply it strictly the way the South China Sea arbitration did, the 2016 Merits Award did, in which case, again, in that case, you will expand the area of the international seabed area, or will you apply it less strictly? And then, of course, the effect of climate change, as can be discussed much better by Dr. Schofield, right? Effect of climate change, and whether or not you have ambulatory baselines, and as a consequence, ambulatory meets and bounds of maritime zones, including continental shelves. Next slide. Okay, by the way, that's us. I would like to note, two of the people here have already passed away, Dr. Teodoro Santos of NIGS and Mr. Rolando Peña. I'm afraid our country has not fully recognized them. I would like to note that they are some of the heroes who made the Benham Rise possible. Mr. Rolando Peña and Dr. Teodoro Santos of NIGS. So this is for the Benham Rise, and that's for the West Palawan region. Next slide. Okay, note the legal regime of the area is defined by multiple agreements, the UNCLOS, the 1994 implementing agreement, as well as various ISA regulations, including those that ISA will enact at some point. Next slide. Now, what is the role of ISA? Sorry, what is the rule for the international seabed area? The international seabed area is covered by the regime we call Common Heritage of Mankind. Although nowadays, I suppose we should call Common Heritage of Humankind, right? What is that? What does that mean? Number one, it may not be appropriated by any state. Number two, it is open to the peaceful use of all states. Number three, next slide. The management is internationalized by the International Seabed Authority. It is under international management, although the functioning of that authority was heavily modified and revised by the 1994 implementing agreement. Next slide. The benefits must be shared for the common good of humankind. Although, as I noted earlier, when it comes to the technology transfer arrangements, that was now been modified to take into account market conditions. Next slide. So, biodiversity beyond national jurisdiction. I'll just said just a little more. Next slide. The ABNJ only recently came into effect after it was signed in 2023. One of our colleagues in IMLOS, Professor Jacqueline Espinilla, was actually part of the very last leg of that negotiation. What does it cover? As I noted earlier, it covers the international seabed area plus the high seas water column. Next slide. So what does it mean? It established several new organs. Next slide. This is a map of the organs from Professor Cosme. Next slide. And then what does it include? Number one, benefit sharing from marine genetic resources and digital sequence information. Digital sequence information, by the way, it's because genetic information is actually code. I can discuss it with later. The scientists can explain it better because it's basically the code of the codons of the nucleotide combinations, ACTG, adenine, cytosine, thymine, guanine. And these combinations are codons. Every three is a codon. And that codon, one or more codons, can form a gene, right? And that is actually digitizable information. And that information is valuable, and the proceeds, any commercial proceeds from that information should be shared as well under a framework that will be defined later by the Conference of Parties and the Finance Committee. Next slide. Okay, there will be area-based management tools, including marine protected areas. Next slide. Every state must conduct environmental impact assessments, not only for activities in the area beyond national jurisdiction, but even for activities in its national jurisdiction that may have an effect on the ecology of the area beyond national jurisdiction. Next slide. And then, policy options. Very, very last part. Next slide. Number one, okay. there is a donut hole, and the donut hole is part of the South China Sea, which is a semi-enclosed sea. Now, under Part 9 of UNCLOS, the various littoral states and other relevant states and organizations must cooperate in the management of this area, and that is an option for the Philippines. Next slide. Now, another one, not my idea, but an idea of Dr. Lan An of Vietnam's Diplomatic Academy, Vietnam, proposed that the littoral states should initiate already the process of making an ABMT. Now, will we succeed? Probably not, because it is subject to possible objection. Nonetheless, the initiation of a possible ABMT is the sovereign prerogative of states, which they may already initiate. And we can discuss later the ramifications of that from the perspective of international administration. Next slide. Okay, next slide. Now, we may also consult parallel to the CLCS process on the delimitation of our ECS. Now, can we actually make a claim to the extended continental shelf without going through the CLCS? If you look at Article 76, paragraph 10, probably not, because it must be subject to favorable recommendations. But there is actually a controversial contrary view that the continental shelf is an inherent right of states. And as we note from the Bangladesh decision, it can actually be resolved upon by ITLOS even without going through the BBNJ process. So there is a controversial point that you may already start discussing now. Next slide. Enact municipal legislation on seabed mining, including whether or not we want to become a sponsoring state, but with the responsibilities of a sponsoring state. Next slide. And start legislating on how we will define surveys, marine scientific research, and resource exploration. This is relevant because of the Supreme Court's decision on resource exploration on the JMSU, but also relevant from a security perspective. Next slide. Because we have the legal gray area of the surveys conducted by the People's Republic in the Benham Rise, on the basis of which they made proposals for new names under the Subcommittee on Underwater Feature Names. But technically, they didn't violate our own clause because it was a survey, not marine scientific research. So, should we plug that legal area by maybe expanding the definition of marine scientific research and clarifying that it means surveys? Maybe not. That's up to our policymakers. And finally, one last slide. We need to consider the vulnerability of the high seas, sea lines of communication in our security planning. Security planning because if a blockade, for example, has subject to the doctrine what you call continuous voyage, where continuous voyage, for example, among other considerations, basically blockades can be done at a distance, not only near to the target area, and for future contingency planning for times of armed conflict, that may be something we should consider as well. Next slide. Last slide. Thank you all very much.
Thank you so much, Professor Silva. The question and answer portion begins now. Thank you.
There was a question earlier. Professor, I think there was a question earlier, yeah.
Mr. Aquino?
Okay, yes. So for Professor Cosme, very basic question. Sorry, I'm Attorney Aquino from Leyte Colleges. Very basic question. In the new law, we included low tide elevations in the 200 nautical mile zone, but we didn't include the rocks in the definition. But you gave us a summary of low tide elevations and rocks that were identified in the RBJ. So I guess why didn't we just include the rocks in the definition? I don't know.
Oh,
Yeah.
because rock, as will be discussed in depth later, maybe this is a good segue later to Professor Schofield's lecture, is that rocks are considered islands under Article 121 of UNCLOS, and so they may be subject to appropriation. So, and since some of these features are subject of territorial disputes are not part of the arbitration. Did that answer the question? Maybe Professor Scoville can add.
So was it a strategic reason why we don't include it in the definition or a technical one?
Because we cannot yet include, if it's still subject of territorial dispute, we cannot yet legally include it in the definition of our EEZ, or we cannot yet include it as part of our EEZ since these features are still subject of territorial dispute. So even if it is within the EEZ, so basically, so within our 200 nautical miles, there are rocks that are subject of territorial disputes. As will be discussed later on, these rocks can generate up to 12 nautical miles of territorial sea. So these portions, so it still depends on what on the settlement of the dispute of the territorial issues or on the territorial sovereignty, what the status, what's going to be the status of the maritime waters surrounding these rocks. Okay, thank you. Yeah, that answered the question. Do we?
Mr. Salpe?
Thank you very much. I actually don't have a question, just added information again and a sentiment. Added information to the question of a fellow participant. This was mentioned earlier that the Philippine EEZ is in Tagalog, butas-butas. There are holes because the high tide features located in the EEZ are not EEZ itself because these are land features and they have territorial seas, 12 nautical mile territorial seas in each high tide feature there. So technically, these are within Philippine EEZ, but not Philippine EEZ itself. And my sentiment is that I know that ABS-CBN is a partner of this, but I have nothing about the ABS-CBN, but my sentiment is about their post one day ago. Look, aerial view of Pag-asa Island. Chinese vessels, including Coast Guard and maritime militia, spotted near Philippine-occupied feature in the West Philippine Sea. As presented earlier by Attorney Ana Cosme, Pag-asa Island is located outside the Philippine EEZ. So I think the Filipino public should not be confused or should not be emotionally triggered immediately, because the first question should be whether such vessels are navigating within the 12 nautical mile territorial sea of Pag-asa Island or outside the 12 nautical mile territorial sea of Pag-asa Island. Considering that Pag-asa Island is outside the Philippine EEZ, if the Chinese vessels are navigating beyond the 12 nautical mile territorial sea of Pag-asa Island, then it is technically navigating within the high seas subject to flag state jurisdiction, not coastal state jurisdiction. Thank you.
Oh, I just like to respond to that. First, Pag-asa Island was not part of the South China Sea arbitration. It wasn't part of the features that was that the Philippines sought to clarify. So it wasn't. So there's no determination from the tribunal whether it is a rock or an island. And currently, we know that Pag-asa Island is under, although it is there's a dispute on its territorial sovereignty, the Pag-asa Island is under the occupation and control of the Philippines.
There was a question by Mr. Abad.
Yes, thank you. Yes, I'm June Abad. Here in our region, we have a Southeast Asian nuclear weapon-free zone. It's a 30-year-old treaty. And while it has been ratified by all ASEAN countries, none of the nuclear weapon states have ratified or acceded to the accession protocol of this Shanfest Treaty. I remember that when the Nuclear Weapon-Free Zone Treaty was being negotiated, one of the reasons given by those who advocated for the inclusion of the EEZ was because we have an obligation to protect marine environment in our exclusive economic zone. And that's why EEZ was included in the zone. So my question was, were ASEAN states correct in including their EEZ in the ASEAN Fest Treaty, and as a consequence of it, none of the nuclear weapon states have acceded to the protocol. What is your view on this, please?
I mean, it was unusual for the ASEAN states to include the exclusive economic zone because the other, as you mentioned, the other nuclear-free zones do not refer to
the nuclear weapon states have not signed the protocol of accession.
Oh, no, I understood that point, but there's a series of different regional nuclear-free zone treaties, but I don't believe the other treaties reference the EEZ, so it was unusual that it was included within this, and you're correct, as I understand it, the nuclear weapon states have not agreed to be bound by them. I think what it does is so much of international law is about communicating the expected standards that we have for states and other actors within the international system to adhere to standards. So even though the nuclear weapon states are not formally bound as a matter of international law, I mean, I do still think it is worth within a regional treaty stating what the expectation is for the countries within that region, and those countries then acting accordingly, because it still sends the message to the nuclear weapon states of what is considered acceptable and what is not. So I always think that there is some diplomatic value in that, and it can ultimately still influence the shape of international law as it develops as well. So I see it worthwhile sort of thinking about how the international lawmaking process goes and how it interacts with the diplomatic messaging as well. But obviously, if they're not formally legally bound, then there's limited legal consequences that follow for those states, if not no legal consequences. I don't know if the others wish to add.
Yeah, I quite agree with that. It is, in some ways, I can think of it as a declarative agreement rather than a really practically enforceable one. Because in any case, number one, if you're going to enforce it, you're going to enforce it against military vessels, which have sovereign immunity in any case. So it really is subject to the voluntary compliance of the nuclear power states whose goodwill will be relied upon. Nonetheless, it is an aspirational standard and perhaps a lawmaking act, because after all, as noted in the legality of nuclear weapons case, one of the reasons why we're concerned over nuclear weapons is precisely its effect on the environment. So one might argue that as an ASEAN country, I am concerned of the environment of the EEZ as well. That's just stretching it far, but again, law develops that way, by stretching the law and customary law and the interpretation of treaty until you can get more consent by the international community.
And with that, that concludes our third session. Let's give a round of applause to Professor Klein, Attorney Cosme, and Professor Silva. Thank you very much. At this point, ladies and gentlemen, let's have a 10-minute break. Our next session will start at 15:45. So you may grab your coffee outside or have a toilet break and be back on time for us to start with the fourth session this afternoon. Thank you very much.